Hi, Alicia Daniel Hall, Florida estate planning, probate attorney, and realtor. If this is your first time visiting my channel, please don't forget to like and subscribe so that you will be notified as soon as I upload new estate planning videos. In this video, we're going to discuss what happens if you die without a will in Florida. If you die without a will, there is a state statute that lists who will be the beneficiaries of your estate. And believe it or not, in many situations, those people are not necessarily people you would have wanted to have named in your will if you had prepared one. The process of assets being transferred without a will is referred to as intestate succession, and every state has a statute that governs intestate succession. The statutes are all pretty similar, but there will be nuances depending on which state you're in. Here in Florida, the relevant statute is section 732.101 through 109. What we are going to do right now is review the Florida intestate succession statute. When someone passes away without a will in the state of Florida, the first question that needs to be asked is whether that individual was married. If they were married, then the next question that needs to be asked is whether that individual had children. If they were married and did not have any children, then their spouse receives 100%. If they were married and have children, you next have to determine whether those children are the children of the spouse or if those children come from another relationship. The first thing that the statute says is if someone passed away without a will, then their assets are going to be transferred in accordance with state law. Next, we go into what the spouse, the surviving spouse, is entitled to. And there are several parts of this provision depending on whether there are descendants of the person who has passed away, who is known as a decedent, and also whether the surviving spouse has any descendants. There are 4 different subsections dealing with what the spouse is entitled to. First and foremost, if the decedent, that's the person who passed away, does not have any descendants, so no children, no grandchildren, then their surviving spouse takes 100% of the estate. If the person who has passed away has 1 or more descendants, and all of those descendants are also descendants of the surviving spouse. So in other words, your children, your grandchildren are also by blood related to your surviving spouse. And your surviving spouse does not have any descendants of their own who are not related to the person who has passed away. In that case, the surviving spouse receives 100%. So let me give you an example of what that looks like in real life. I pass away without a will, and I am married, and we together have 2 children. In that instance, because my spouse and I both share those 2 children, my spouse will receive 100% of the estate. Next, if the decedent passes away, and they have descendants, lineal descendants, who are not lineal descendants of the surviving spouse, then the surviving spouse is entitled to 50% of the estate. So real world translation. I pass away, I am married, but I had 2 children from a prior relationship. In that instance, my surviving spouse will receive 50%. We'll talk about the other 50% later. Now for the 4th situation dealing with what a surviving spouse is entitled to. And this one concerns what happens when there's a surviving spouse, we have descendants of both the surviving spouse and the person who's passed away, and the surviving spouse also has descendants from another relationship. In that instance, the surviving spouse receives 50% of the estate. Real world translation of subsection 4 is, I pass away, I have a surviving spouse when I pass away, we share children, but my surviving spouse also had a child from a prior relationship. In that instance, my spouse is going to receive 50% of my estate. Florida Statute 732.103 is titled Shares of Other Heirs. This section outlines what happens to that other 50% we discussed before when talking about the spouse, and it also deals with what happens if someone passes away without a surviving spouse. First subsection says that other 50%, or if they pass away without a surviving spouse, will go to their descendants. But what happens if they don't have descendants? Where does their estate go, and or that other 50%? Someone passed away in Florida. They don't have a will, they don't have a surviving spouse, and they don't have descendants. Their estate is going to pass to their parents equally. Or if only one of them is still alive, then that parent will receive 100%. Next up is if someone passes away, they don't have a will, they don't have a surviving spouse, they don't have descendants, and neither of their parents are still alive. In that instance, their estate is going to pass to their brothers, sisters, and the descendants of their brothers and sisters. So a real world translation of what that looks like is your siblings would be inheriting your estate, but in the situation where one or more of your siblings have already passed away but they had children, their children would still inherit their parents' share. Now, if you don't have living siblings or descendants of siblings, then your estate is going to be going through your grandparents' line, and it's going to be 50% maternal, 50% paternal. So first and foremost, are there any grandparents alive? If so, then they're splitting it equally. If only one of your grandparents is alive, then they're going to receive 100%. And if we don't have any living grandparents, then the estate is going to be passed to aunts, uncles, and just like with the siblings, descendants of aunts and uncles. Now, if you have a situation where there's no one alive from either side, so no one's alive from the maternal side or no one's alive from the paternal side, the surviving side receives 100%. Remember before I said they split 50-50, but if they're not alive on one side, then the other side is going to take 100%, and the estate gets divided among whomever is involved. So the descendants, the aunties, the uncles, and the descendants of the aunties and the uncles. Someone passes away and they do not have any maternal family and they don't have any paternal family, but they have a deceased spouse. Their estate is going to pass to the descendants of their last deceased spouse, as though that deceased spouse was actually alive when they passed away, and it's going to be passing in accordance with the intestate succession rules for the deceased spouse. And then the statute clarifies how to deal with certain situations. For example, 732.105 deals with half-bloods. Half-bloods receive 50% unless everyone is a half-blood. In that case, then everyone's going to receive 100% of whatever their share was when you go through the whole breakdown. And 732.106 talks about what happens with after-born heirs. So these are individuals who were conceived before the decedent passed away, but are born after the decedent has passed away. In that instance, those individuals are going to receive their intestate share as though they were alive when the decedent passed away. 732.107 is the scariest provision. If you pass away and you have no blood relatives anywhere, your estate will escheat to the state of Florida. And what that means is your estate goes to the state of Florida. All of the assets will be liquidated and the funds will be transferred to the state chief financial officer. It's going to sit in the state school fund. Now, there are 10 years, so there's a 10-year period where any family member that pops up out of the blue, sometimes you have long-lost relatives, those people can in fact come in and claim their right to the fund. So there's a 10-year period for them to do that. And 732.108 talks about adoptive children as well as children born out of wedlock. I am not going to get into the nitty-gritty on that provision. As you can see from this breakdown of the intestate succession statute of Florida, quite a few people that you probably would have wanted to include in your estate plan are not going to be included. So for example, if you never did get married, but you have been living with your significant other for 25 years, and this is the person that you would have wanted to leave everything to, you would not be able to do so with the intestate succession statute. Also, your friends, your godchildren, unless they fall in the line of succession and, well, we're at a point in your succession where only that group of people are inheriting, then they're not going to receive anything. There's no ability to leave anything for charities, and there's obviously no way for you to control when those assets are going to be distributed. The people who are entitled to receive pursuant to intestate succession will receive their share through the probate as soon as the probate is completed. So, if you are ready to take control of your estate rather than leaving it into the hands of the Florida legislature, click on the link below and schedule your free estate planning consultation.